Hi, this is Professor Swift, and today we're going to talk about a case involving attorney-client privilege, the Loving case. And with me today are Pradeep, our graduate assistant, famous for being a great graduate assistant, and Sam, who is from Chicago, likes the Bears, but we like him anyway. Okay, so attorney-client privilege, it's important for you to understand this concept. It means that what a client tells an attorney is private. And if someone comes across it, let's say it's an email or it's a letter, they're not supposed to read it. Typically you'll see at the bottom of the email or the letter or the document that in fact it's attorney-client privilege. No one else is supposed to read it. In this case, the employer did. And so Sam, how was it that the employer started reading the attorney-client privilege information from their employee to an attorney?
So to begin, we have to talk about how the laptop relates into the case. So this was a company-provided laptop, which is very important because basically what happens is after they give her this laptop, she's expected to do work and all company-related needs with this laptop.
And is there a policy that tells her that?
Yes, there's a policy that describes the monitoring process of which she would be need to relate to, and also the work that you would need to attribute to possess this computer.
Now, did the policy say that she couldn't use email, her own email? She couldn't use that server?
Not specifically. It was super vague, which is what causes problems later in the case.
Okay. Why was she contacting her attorney?
She was contacting her attorney just to discuss situations that she was having at her work or employment.
All right. And how did the employer come across those emails? Because were those emails on the work server or were they someplace else?
So what happened, and it wasn't to her knowledge while she was writing these emails to her attorney, they were saved on a hard drive. And during the discovery period, when the company was trying to pull out all these data facts about what was happening, they came across these emails that were supposed to be confidential. And it's very important to know this because they were obviously confidential. It was super specifically labeled on the email that they were covered under confidentiality between her and her attorney.
Okay. So they find them, and then what did they do with them?
They use them for the discovery period, and they attribute them to the case.
Now this is very serious, myself being an attorney, because if you see something that's marked attorney-client privilege, you're not supposed to read it. But they did, is that correct?
Yes, they did, even though it plainly said that they weren't supposed to read it.
All right. Then the next thing I want to ask you is, as far as her email, you said it wasn't on the employer's service, and that in fact they found it on a hard drive. What kind of email was it? And perhaps we could put those words up as far as the type of email that it was. Was it password protected?
Yes, it was password protected, and so it was password protected, and it's very important to know this because she had the right to have her personal email on there, and simply because the monitoring process was there, it was super vague, and it didn't deny her the right to have a reasonable expectation of privacy for this email. Okay,
so it was password protected. You said that it was web-based, which means that it wasn't through their server. It was actually like a AOL or Gmail or something like that, right? Okay. And then was she told that it could be on the hard drive?
She was not. She was unaware about that fact.
Okay. So would you say that she had a reasonable expectation of privacy because of the vagueness of the policy, and also the fact she wasn't specifically told that her private password-protected email could be saved on the company hard drive?
Yeah, I think she had a reasonable expectation for privacy because she was unaware of that process of which they kept her information on the hard drive where the employer was able to access it later. She was just totally unaware about that fact.
Okay, so let me ask you this. If you were working at a company and someone said, hey, look at this, we've got all of these emails from her attorney, what would you do?
Well, I'd make sure that our monitoring process was super specific in the way it was labeled, because otherwise, even with that client-attorney privilege, the fact that they shouldn't have done it anyway just because their monitoring process was so vague So to begin with that, I would have to suggest that we look over the monitoring process and make sure that we're actually allowed to do this, and it's something that our employees aware of that we can't do.
All right, I would say to be very careful with attorney-client privilege, you should contact an attorney and bring this to the attorney's attention and ask him or her, can we read these, or are these something that we have to disclose to the other side and we're not allowed to? And the attorney, not yourselves, would make that determination.
Okay.
Okay? The second thing is that you should probably make sure that people are only using on your laptop, if you own it, the company owns it, they're only using your email service.
Mm-hmm.
Why do you think I say that?
Well, it's important to differentiate the purpose between work and personal time. So by doing that, by saying that you're only allowed to do work email on this laptop, it kind of separates the fact between personal email and work and employment stuff.
Do you think that the expectation of privacy, if you say this is a work computer, or this is a work phone, this is a work tablet, you can only use it for work, and we own everything on this on the hard drive? What do you think about that?
Well, I think it's important for the employee to understand that before getting this laptop, because at the time there should have been a clear judgment call as to whether she was allowed to use personal email or to use social media or something like that, because it wasn't labeled properly and it was just too vague in general.
Okay, but if you are specific
Mm-hmm.
and you have a computer and you say only use this for work and we will be monitoring it on a regular basis and any information on there we own, do you think that would be acceptable?
I think that would not be acceptable for her to use her. She would not have reasonable expectation of privacy in that case.
Okay, and the employer then could read whatever was on the computer.
Yeah, I believe so.
Okay, I still think I should tell you that you should be careful about attorney-client privilege information. I still think you should contact an attorney and have them help you determine whether or not you can read it.
Okay.
Okay?
Sounds
Do you have
good.
anything else you'd like to say?
Yeah, well, I wanted to go a little bit further into
Sure.
what happened. So in the trial court, they found that Stengart waived her right to attorney-client privilege because she typed the emails on a company computer. So she tried to appeal that, and the appellate court disagreed with the trial court, who originally had the idea, because while the company did have a monitoring policy, it was far too vague, and it did not disrupt her right to have an expectation of privacy.
Okay. Anything else?
Nope, that's pretty much it.
Good. Do you have any questions, Pradeep?
No, I think that covers everything. Thank you.
Great. Thanks a lot, Sam.
All right, thank you.